complicated time in our life. And that is the subject of today's show. My guests are Dr. Chelsea Del Rio from the Academic Affairs, Division of Academic Affairs, Department of Social Science, and Dr. Shannon Proctor of the Humanities Department's Philosophy area. Welcome, doctors. And I am aware that we do have at least one audience member, to Dr. Sherry Carr, who actually, I'm trying to remember the genesis of the idea for this show. I mean, May It Please the Court is a series of ongoing segments we've done here on LaGuardia Web Radio WLGR, where we typically play oral arguments from the Supreme Court. We've been focusing on reproductive rights, those particular cases. And Dr. Proctor's been on before, typically with Dr. Albrecht, Vera Albrecht, who's now our chair of humanities and a little busy. So she's she's unable to make these shows anymore. And but I think it was Dr. Carr who initially had the idea that we would talk about something very important that's happening, which is in the state of Texas, where they have now passed a law where they've made it illegal. You have to correct me here again, doctors. Illegal to have an abortion at 6 weeks or later. I believe it has something to do with the heartbeat of the. It's not even a fetus yet, right at that point, right? Yeah, and the Supreme Court chose not to hear a case considering the unconstitutionality of that law, which is now allowing the Texas law to go forward. Though I believe there are things happening in the court, right? But sorry, go ahead, Doctor. Right. And Dr. Riccio, by the way, is also somewhere in the universe watching us. Though I think she's teaching as well, so she's monitoring the Twitch stream. I can't. By the way, Dr. Carr, I can't say hello back because in order to communicate through the Twitch chat stream, I have to become a whatchamacallit, a member of Twitch, and I've yet to do that, believe it or not. Dr. Carr, though, is saying she can't hear Shannon, though. We hear you. Say hi, Dr. Proctor. Yeah, we hear you. I hear you fine. Anyhow, what's unusual also is that we would typically spend the first half hour listening to oral arguments. There are no oral arguments because the court chose not to hear the case. So we're really basing it on what the two of you pretty much know about the case and the complexities of it. But I did say to Dr. Del Rio that usually, Dr. Proctor's been on the show many times, and so the audience knows her a little bit. But I want to give you an opportunity to kind of introduce yourself, talk a little bit about your background, your studies and things before coming to LaGuardia.
is a whole other world of social movement activity in the 60s and 70s, and that is lesbian feminism, which was a really vital component of sustaining gender and sexuality politics through that time period. With regards to reproductive justice, I've been active in this area for over 20 years. I've been a clinic escort all that time, and I run a clinic escort program in the Bronx today. That means walking patients into clinics where there are anti-abortion protesters trying to block them. And I've also done work on the other end of the reproductive justice spectrum, trying to ensure access to fertility treatments. And so I've done campaigns around that issue as well. And I came to LaGuardia, I came to New York to work at LaGuardia, and I'm the coordinator for the history option, and I teach U.S. history courses, women and gender, African-American history. I've taught the politics of sexuality and political science. I'm involved in the women, gender, sexuality studies option. So anything around gender and sexuality, I've got my hands in here at LaGuardia.
Yeah, it was good. When while you were talking, it reminded me of something. Have you seen? There's a show on Apple TV called Sex Education, and there was an episode where one of the young women was getting an abortion, and her experience was, this is in the UK. Her experience was that she is trying to enter, and it's already a pretty charged situation. But there are people outside. There was basically trying to dissuade her from going in, and saying some pretty awful things on the way in and on the way out. And you're telling me this is happening in the Bronx?
It happens throughout New York City. It happens at Planned Parenthood clinics in Manhattan, Brooklyn, and the Bronx that I'm aware of. It happens at Choices, which is in Jamaica, Queens. It happens in at least 2 independent clinics in the Bronx. And there are also other things that happen. New York City for Abortion Rights recently helped bring about an end to a campaign where a lifelong anti-abortion figure in the Catholic Church who has literally been getting arrested under laws since the 90s, for infiltrating clinics, had been leading a monthly service and then marched to the Planned Parenthood in Brooklyn with folks from that church. And so that has recently been put on pause. But this happens throughout New York City. It's much worse in many southern states where abortion access is much more under attack. But at the clinic where I escort, there can be maybe as many as 20 or 30 people praying, and then there can be anywhere from 1 or 2 to 8 or 10 what they call themselves are sidewalk counselors, and they will literally step in front of patients trying to approach the clinic, try to delay their entry for as long as possible so that they can try to dissuade them from going into the clinic. Some of them are so aggressive that they push us, the escorts. They will literally try to get into cars as patients are arriving. And then there are other campaigns such as 40 Days for Life and Love Life, which also come out to the clinic and deploy a range of tactics.
Yeah, I can't. It boggles my mind that things are. It's already such a complicated situation to then have to deal with that as well. I can't imagine. And I just want to say I'm being told that we are having technical difficulties. There's an announcement on the Twitch stream that says, but now it looks like our volume levels are back on, so we didn't miss any of that. Okay, so let's get into the meat of it, which is this particular situation we have in Texas. And let's begin with, I'm guessing, so this is a law that was passed by the Texas legislature, Republican. And again, the technicalities of it are that it forbids abortion, and anyone who is actually doing the abortion or aiding and abetting in the abortion, would that qualify as you being escorting them to the
Absolutely.
Yep.
Absolutely. At the time that the whatever we're going to call it, the what at 6 weeks, what do we call what do we call it? A zygote? What do we?
It's an embryo. You know, we refer to this fan, right, rather than a heartbeat fan. But yeah, so it is not yet a fetus, so an embryo. I mean, there are developmental differences, but zygote, embryo, and then fetus. Yeah.
And you can see I paid attention in my sex ed classes, right? So, and one of the things that complicates is that, right, that most women would not know they were pregnant at 6 weeks, right, unless they, for whatever reasons, were like testing regularly, right?
I do just want to say that while women are most obviously targeted, when we talk about abortion, we need to keep in mind that that not only women need abortion. So it targets anybody regardless of their gender identity who might need abortion care. Okay.
So you're saying someone who would not identify as a woman, but who could be pregnant.
Right.
Okay.
So the law, I mean, mostly women are affected, and that is who is targeted, but people other than women get abortions.
Right. But again, one of the things that complicates this is that a person would not even know that they were pregnant for any reason, unless they were being hyper-vigilant.
I think that there's this is something maybe Chelsea you can back up here, is that a lot of times even someone who was attempting to get pregnant, right, who was paying much more attention than the average person to their cycle, it is quite possible they would not know within the 6 week time. And really, while we keep saying 6 weeks, it really is the heartbeat. That is the determining factor. So it could be slightly more or arguably slightly less than that period of time, though that's the average time.
Because it would also be, it's difficult to tell exactly when somebody is inseminated. What term would we use for that, right? I don't know. I'm at a loss here. But so this all complicates. So it's passed by the legislature, and I guess it's challenged immediately, right? It was challenged by folks because it makes its way to the docket of the Supreme Court, and then the court chose to not hear the case. Is that the timeline?
Yeah. So like you were mentioning, obviously we have typically listened to the oral arguments, right? There were no oral arguments here because this was on what gets called the shadow docket. So I was trying to get the proper definition up here. Basically, the shadow docket is where like an emergency injunction can be put in place. So in a sense, it's like if there is an imminent harm that can happen to someone because of a law, that the court can sort of forgo oral arguments. If I've been looking over the actual decisions here, so right, it's the case itself is Whole Women's Health et al. V. Austin Reeve Jackson Judge et al. So it's quite a mouthful, the case name there. But so there is a decision from the court. It is extremely short, and there's I think 3 separate dissents. The decision is ultimately saying the problem being that the court can only enjoin a state actor. They can't enjoin a law itself. So they can't, in a sense, that all they can do is prevent a state actor from enforcing a law. But the way this law was written was such that this was the exact problem that would be encountered if someone attempted to get it overturned, right? That was the entire reasoning behind creating this arguable vigilante system in which it is just citizens of the state of Texas who can bring suit against someone who has aided and abetted in an abortion. So the court's reasoning in the opinion is that because there is no state actor to enforce this, there is no one that they can enjoin, therefore there is nothing that they can do about it with the way the case was brought, though of course they would never claim this is a constitutional law yet. They're saying maybe there's other cases that can be brought, but this case as brought cannot actually proceed.
So maybe we can just take a step back. I mean, so we've talked about the fact that what the law does is essentially provide abortion care after 6 weeks. But all of hundreds and hundreds of similar sorts of laws have been developed in states around the country. Since Roe v. Wade was passed or decided in 1973, over 1,300 laws have been passed in that time to restrict abortion access. And nearly 50% of those laws have been passed in just the last decade. 2021 already has seen more anti-abortion laws passed than any other year in history. We're already at 106, I believe it is, anti-abortion laws being passed, which breaks a record of 89 in 2011. But what makes this case so radically different, all of these attempts at like 6-week abortion bans have basically had injunctions issued while they make their ways through the court. And that's because the state is tasked with enforcing them. And so there has been a clear case of making a case of getting an injunction, right? There's a clear person to target in the appeal or in the suits for injunctions. But in this case, there is no state mechanism for enforcement. It says private citizens, they don't even have to be in Texas, can bring a suit against anybody who facilitates an abortion, whether it's a Lyft driver, the medical staff, even if it's like a receptionist at a clinic. Anybody who facilitates abortion care after 6 weeks can face a suit. The minimum damages are $10,000 plus legal fees. If you are not found guilty, if you are not convicted under this law, you do not get to recoup legal expenses. So even if you evade legal punishment, you're still out the money that it takes to defend yourself. A doctor can be sued on multiple times for the same case, right? For the same abortion case. So but it is this component that Shannon is talking about, that because it's a private citizen, that is what the Supreme Court is speaking to. So they haven't actually heard the case itself. They have, or they haven't decided essentially on the constitutionality of the law. They have said we can't take action to issue an injunction because the legal component of private citizens enforcing the law is so messy, is essentially what they're saying. And the Texas Right to Life legislative director has said explicitly that the law was created for this very purpose. This law was created to complicate judicial review.
But my understanding is that the decision to not hear it was also kind of done like late in the night or on the weekend. It was not done classically the way things are done, and there were justices who were not happy about it.
Oh yeah, so there were 3 dissents, and each dissent is significantly longer than the decision. Than the actual opinion in the ruling in this case. And yeah, that's the shadow docket, right? Which, again, the so-called shadow docket is what you're talking about there. And there's, I think, to tie into what Chelsea was saying, and something we've been saying on this program a lot, is that there's some very cynical political motivations behind this law. It's arguable that they don't actually want any cases to be brought, because once a case is brought, then it opens up a whole nother layer of judicial review, right? Then it's much clearer in terms of who the injured party might be there, as opposed to the potential injured party. And I think there's been a lot of arguments in the press about the political nature of this so-called shadow docket, of the justices, of the processes by which we end up with the Supreme Court makeup that we have right now, that there's a lot going on here that is, one might argue, the manipulation of people who hold anti-abortion views to achieve other political gains that are very disconnected from the question of abortion and its legality.
Yeah, I mean, so in the dissents, which, as Shannon said, are longer than the decision itself, it's Kagan, Sotomayor, Roberts, and Breyer in the dissent, and each issued a statement. But these dissents address like the use of the shadow docket, as well as the way that abortion is being handled. And essentially what they're saying is that the refusal to take any sort of action violates essentially the precedent for how the Supreme Court has handled abortion cases for the nearly 50 years since Roe was decided. That they essentially rewrote how abortion cases would be handled with full briefing arguments. And so the perception is that given what a detour this is from how the court has acted with regards to abortion, that this is foreshadowing what is going to happen at the Supreme Court level as new abortion cases present themselves, one of which will begin oral arguments on December 1st.
One of the unusual dissents was actually Roberts, right? Who is the Supreme Court justice. Correct. And it's typically a conservative, thought as a conservative politically, and even in his tenure as Chief Justice. So that was particularly what his dissent was about the procedural way it happened. Is that really what it was about for him?
And I think the clearest, he said that this law permitted the state to avoid responsibility for its own law. So right. He spoke to the procedural component of how this law was written, and the fact that there is this issue of constitutionality. He's not speaking to abortion rights itself, but that this law does in fact violate standing constitutional law with regards to Roe.
And my understanding of this particular law, the Texas law, does take into consideration either health issues or, for example, rape.
It does not.
There's no exception.
It does not either, because I know there's another law that's just been passed, and it ignores that as well.
Is that in Mississippi, Chelsea? I can't remember where the next.
There's a brand new one, that's just come out. Well, for another show.
Yeah, so it will probably.
There have been 109 laws passed this year so far.
Yeah,
so
well, I think
is a full-time job.
That's clearly that's one of the major legal fears that comes up here is how many other states were just absolutely ready, willing, and able to adopt this approach when it comes to anti-abortion laws, and maybe one way that this problem might get resolved could be now that the Justice Department is getting involved in a deeper level and is arguing that they have standing to bring suit because this is taking away constitutional rights of citizens. Otherwise, the question, like we were talking about before the show began, is to where does this end? At what point, if this is an acceptable way to frame a law, there are a tremendous number of constitutional rights we have that people actively debate, right? I think obviously the obvious one that comes to mind are laws about gun control, right? And this should be concerned, this procedural mess should be concerning to everyone. Absolutely.
So what you're saying is that I could bring suit against somebody as a personal citizen concerning, the fact somebody carrying a weapon and, saying that, that would be a hazard or something, and sue them into oblivion.
Which would then seem to get rid of any sense of any kind of federal legal protections, because it would then just go back to states. Whoever is in power in the states, whoever has the option to make state law, would just be able to to take any issue that they disagreed with that is federally protected and make this same kind of vigilante law for it. Yeah.
Okay, but it's 12:28, so I'm going to just do a quick station break here. The show is What's Going On. I'm your host, Hugo Fernandez. My guests today are Dr. Chelsea Del Rio from the Division of Academic Affairs, Department of Social Science, and Dr. Shannon Proctor from the Humanities Department's philosophy area. And we are talking about all of the things going around on this Texas law, which bans abortion at the first sign of an electrical impulse, or at 6 weeks, whichever comes first, and how the Supreme Court responded to it, and how it's ongoing. So where does it stand now? I mean, I understand that the Supreme Court did chose not to hear it, and it's going forward. There was a doctor in Texas who said he was still going to go ahead and keep, doing abortions. And then, of course, now the Justice Department is involved with, the specifics of the law itself, the way it's written. Where are we right now today?
So I'm trying to make sure I'm going to read this to you so that I don't mess this up. So the Justice Department is now asking the Supreme Court to vacate the Fifth Circuit's stay of the preliminary injunction. So there was an injunction brought to the Fifth Circuit. I think it goes in front of, I forget if it's a one-person or three-person panel at that point. I think it was a one-person decision. There was an injunction. That injunction got overturned by the Fifth Circuit. They gave a stay to that injunction. Now the Justice Department is asking the Supreme Court to vacate that stay. In other words, they're asking the court to throw out the law. Again, with the reasoning that we've seen so far is because it has the standing to protect constitutional rights of the citizens of the United States.
But it wouldn't, it doesn't throw out the law entirely, right? It pauses it while it makes its way through the courts to determine the legality of the law itself. The issue here, though, is that before, say, this law could become in its entirety, before it could come before the Supreme Court, there may be Supreme Court decisions that have, for example, already overturned Roe v. Wade. So there is a case, Dobbs v. Jackson Women's Health Organization. Argument begins on December 1st, and it is addressing a 15-week ban passed in Mississippi. And within the world of reproductive health advocates, there is a significant concern that this case, the way that the court decides this case, will essentially invalidate Roe v. Wade, which, if that is the case, will leave abortion access to state law. And we know that as it exists now, there are, I believe, 10 states that have trigger laws, meaning that the moment Roe v. Wade falls, this abortion will become illegal in those states. There are another 9 states that have laws like the 6-week ban that would go into effect once Roe falls. And another 9 states that have pre-Roe bans that the state legislatures could essentially revive. So roughly around... and 4 states have passed constitutional amendments saying that people don't have a legal right to abortion in those states. So essentially, about I think at least 30 states could severely restrict, if not entirely ban, abortion, leaving essentially the West Coast and the Northeast as the 2 places where abortion was well protected. 14 states have passed laws essentially enshrining abortion rights within the state. So this law could, the Texas case is making its way through the courts, but Roe could potentially not exist by the time it reaches the Supreme Court.
And, one of the things that also, Dr. Proctor was talking a little bit about this, or maybe not specifically, but we know, like you said, it's been 50 years since Roe. There have been 1,300 laws passed, but also we know that Mitch McConnell, in his role in the Senate, has made it his business to control the nomination process, the approval of Supreme Court justices. He blocked an Obama nominee, and then under the Trump administration, 3 Supreme Court justices were nominated and approved and are on there now. And the court is, even though we had a 5-4 vote there, some people would say it's really like a 6-3 vote. So this has been his long-term plan, McConnell's long-term plan. People have talked about this too, and not just at the Supreme Court level, but also at the other levels, circuit courts, any federal court really, where the Senate has purview over approval.
Well, one of the judges on the Fifth Circuit Court of Appeals was a Trump nominee and is one of the most vocally anti-abortion judges in the country.
Right.
So legally within the government system, there has been an eye on judges that can guide decisions in a certain way, but also the people behind these types of laws have also been developing them with an eye on ways to directly challenge Roe.
And I think it also ties us right back into my political cynicism about all this, right? Because if we look at Trump historically, he was not an anti-abortion activist in any regard. There's a connection between people who truly believe the anti-abortion stance, as well as those who see that this is a way to achieve other conservative goals, right? Is to sort of bring these communities together in voting blocks, right? And like you're saying about Mitch McConnell, and of course it is Merrick Garland was the nominee who was not allowed to go up for a vote, and he is now leading the Justice Department, who's trying to bring these suits. So that's an interesting political layer as well. One thing this also brings up politically, right, is again we come back to the filibuster, certainly, and we come back to the issue about something that Vera and I had said in previous shows here, is like the problem of relying on Supreme Court precedent for the protection of Roe is this precise problem, as opposed to the creation of a federal law that protects abortion rights. But it seems almost impossible at this point in time to be able to pass such a law. And that brings us to, again, the issue of the filibuster, and it brings us to the issue of voting rights and access, and a tremendous number of questions to wonder why it is that the people who have the power to make these decisions don't accurately reflect the views of the vast majority of citizens or people living in the United States.
Yeah, because a federal law, not only would it take would it take a simple majority or a 2/3 majority for a constitutional law, then it would have to be ratified by 2/3.
That would be
states.
A change to the Constitution. Here, we're just talking about a federal. We're just talking. There's a difference.
We're just talking about federal legislation.
Yeah.
But then, wouldn't that be challenged as unconstitutional or something like that?
Well, there's nothing in the Constitution that would prevent a law about abortion. There are people who support abortion's rights who actually would argue there's nothing in the Constitution that protects abortion. That's a big debate for probably the Supreme Court very soon. But there's certainly nothing in there that prevents laws protecting abortion.
I mean, there is the Women's Health Protection Act is something that is in some entity floating around Congress, right? But the question is, like, what is the capacity to actually pass it? Not likely at this moment in time. But that is something that is sort of, amongst the people in Congress who do want to protect abortion access. And part of the issue here is sort of when we're talking about these restrictions, then conversations come up about sort of how the case was argued, how Roe v. Wade was argued. Abortion access has been tied to issues of the right to privacy.
Exactly.
Yeah.
Well, there it is. That's what protected it, was the right to privacy.
And people argue, and I mean, I know we've kind of gone into this we went into this, especially when we talked about Roe, that the penumbras of the Constitution and what does that mean. Certainly from a legal and a philosophical perspective, I would want to argue that we should have tackled this in a different way when there was more support to pass these laws. I think that there's a lot of people, maybe I'm being cynical about this, but I think that there's a lot of people who these laws can affect who don't seem to really have the wake up moment that this is very serious, right? It seems like a lot of people take it for granted that the abortion access. When there are some states, and I bet Chelsea, you know this better than I, some states that make it illegal to even go to another state where it is legal to have an abortion and go get one. Like that, those laws are sort of hiding out, waiting.
I was talking to a friend about that last night. I was trying to remember what state it was. I feel like maybe it was Tennessee. But so far, one of these restrictive laws that was passed, yes, would have prohibited travel outside of the state to access abortion after 6 weeks. So trying to criminalize getting healthcare outside of state boundaries. But again, I think almost entirely, I don't know, Shannon, if you can, but I feel like I'm pretty sure that every single one of these restrictive laws has been, like these sort of 6-week bans, have received injunctions while they make their way through the courts, because the mechanism for enforcement was state authority, and that was an easy, like that's sort of within the confines of how things work and how the courts can take action, unlike the Texas law.
And it's interesting because, again, they talk about how laws like this hurt folks who don't have the money to do something about it. For example, get on a plane and fly to New York or LA or wherever it is, San Francisco. But you're saying now that they're even they're addressing that by basically making, if somebody were to travel to another state, they would also be subject to laws back in their home state.
So it's not,
when they get back, you can prove it.
Economic standing is a huge issue. People of wealth have always been able to get the care that they need. But these laws make it difficult for the people who are already struggling. They make it difficult for low-income people, people of color, queer people, undocumented people, young people who don't have access to solid medical care, who don't have access to birth control, who then have to arrange for. So let's take the case of Texas. You find out you have the most regular menstrual cycle in the world. You know immediately that something's wrong the first day that you miss your period. You have the money to go out and purchase a home pregnancy kit, or you have health insurance and you can go to your OB/GYN. And then even in the perfect scenario, if you have 2 weeks, you have to potentially take time off work. You have to have the money to seek medical care. You have to potentially get child care. You have a 24-hour waiting period in Texas. So even in the best case scenario, these are all issues that are affecting you. For folks who then are leaving the state, which is 85 to 90% of people, at least 85% of abortions happen after 6 weeks. And so then there are people, so let's consider there are Border Patrol checks north of the U.S.-Mexico border that people have to go through to leave border towns. So if you're an undocumented person who needs an abortion, you may not be able to leave this state to get abortion care. So then you're facing forced pregnancy. So this law affects so many people in such radical ways that really are inhumane and forcing people into pregnancy.
And I think, Dr. Proctor was saying before about just, the time it's taken for this the period of time and that it's happened, and the folks that are going to be affected by it who are not on board yet to fight it. It just makes me feel like, it seems like that's an aspect of our country, is that we have these large periods of time where it takes to swing the pendulum back. And if something like this, let's say Roe v. Wade is overturned, and more than 2/3 of the country, it becomes impossible for women to get safe abortions. Once they start experiencing what it's like to live in that kind of culture, again, maybe develop the political, desire to fight back, but it took them 50 years to challenge Roe to this point and be ready to succeed. It may take us 50 years to get the rights back. And it's sad, but it's kind of like one of the aspects of a democracy, right? That it takes a long time to turn the boat around.
Well, yes, but arguably there's not much democracy going on in the creation of these laws,
no.
Right? That it's not representative, not even if we're just talking about a simple majority of the voting public. It's not representative, and it is it's very arguable that Texas doesn't ever expect to have to enforce this law. That really they're just hoping, which is sort of what's happened, is that clinics have severely restricted who they will provide services for because they don't want the potential to get sued. And like Chelsea said, I hadn't even thought about the sheer number of cases that could be brought against anyone who facilitated an abortion. The amount of money, I mean, it's an impossible situation for providers to be put in a situation of. And I know there's some people who read the law as even if you gave someone money, not knowing what the money was for, and that money was then used for an abortion, you would possibly be sort of in violation of this law. It's very far-reaching. It's very undemocratic, and it's a cynical way to try to achieve methods that they could not democratically achieve.
I want to interrupt because we're moving into our question period. I don't know if I'm interrupting, but stage the last 15 minutes. And we do have a question. And also Dr. Carr wanted to hip us up to the fact that a pregnancy is calculated from the date of the last period. So someone could actually be less than 6 weeks pregnant, but through the calculation process of the menstrual cycle, not the actual date of conception, as I was trying to suggest as a knucklehead. So here's a question. If there's time, again, Dr. Carr, would love to hear about experts talk about the history of the ways that abortion has become so politicized in the U.S. For the medical ethics students who would be interested in that. You want and by the way, that's what all these shows have been about. May it please the court, which we began with. I think we started with Griswold, right? Which was, the passing out of condoms and the legality of that. So folks can, but the history probably goes even farther than that, does it, Dr. Del Rio?
Yeah. Well, so one thing that is incredibly relevant to these, the more recent spate of laws being passed is in the same year that Roe was decided, not by coincidence, we see the creation of so there is ACOG, which is the American College, is that the right, of Obstetrics and Gynecology, the American something, ACOG, which is medical professionals who practice OB-GYN care. In the same year that Roe was decided, we have the creation of APLOG, the American Association of Pro-Life Obstetricians and Gynecologists. So this organization was created by anti-abortion doctors. This is relevant because legislators are supposed to follow medical knowledge, medical advice, right? Standing medical opinion. Where there is tension, where there is disagreement over the significance of a medical procedure, for example, legislators can choose which medical information to work with. So essentially what happens is anti-abortion doctors rely on fringe science to make arguments against abortion. Legislators can then choose to listen to APLOG rather than to the majority of healthcare providers who use sound medical information and then use APLOG's information to back up these types of laws. So this is where the medical ethics comes in.
And AMA, the American Medical Association, can't challenge APLOG's.
They're licensed
remarks.
medical providers. They can issue. I mean, certainly the AMA can say this is not accurate information. But where there is dissenting information, no matter how fringe or no matter how questionable, if there's a study by someone who's a licensed doctor who says the world will implode if somebody gets an abortion, legislators can decide to follow that perspective because it's dissenting medical information.
All right. So again, and I think this is something about the including of employers. Dr. Carr wanted to add that. I don't know how that affects the case. Sorry, there's a breakdown between. It's hard to have a conversation through chat while you're doing it live too. We've got a little over 5 minutes left, and wanted to give you both an opportunity to say any last words on the subject, and or if you want to put out any thanks to anyone out there as well for the work they're doing. So who'd like to go first? Dr. Del Rio, would you like to go first? I mean, how about you, Dr. Proctor? You go first, because Dr. Del Rio spoke.
She'll probably have more to provide here in terms of the shout out to people doing great work in this area. So first off, I just want to say thanks. It's been a really great conversation. It's been so excellent to hear the historical perspective as well. Like normally, she's been two philosophers of law and, Hugo Fernandez just going back and forth on this. So it's been really nice to get that more historical context, Chelsea. I would really encourage people who are interested in this, as well as who are interested, if you have any interest in the law, I think it's really important to pay attention to the way in which this case plays out, because as I've said, not that the effects on abortion access aren't important enough on their own, they are, but there are far-reaching implications of this kind of law, and I think every single one of us should be concerned if this is the way to get around constitutional rights. We might as well not have any at all. So that's my cheery end of message there.
So basically making the case that we're going to litigate ourselves to death, right?
I mean, literally to death, because we know that banning abortion does not end abortion, it ends safe abortion. So, I mean, litigation to death, like people die when abortion is illegal, because people take desperate measures to terminate pregnancies. To end potentially in a bit more of an upbeat note, I want to bring attention to abortion funds. So I don't know if people are familiar with abortion funds. There's a national abortion fund, statewide and local abortion funds that essentially their job is to raise money to help people afford the costs of getting abortion care. And this is becoming particularly important when you have so many people who have to leave the state of Texas. You have to pay for the abortion procedure itself. You have to pay for hotel. You have to pay for transportation, childcare, and so on. So you can do some light Googling and find a whole wealth of information about abortion funds. But these are the people who are out there doing the work of ensuring that people do have access to what is a legal medical procedure. There is also a whole world of activism happening often within independent clinics and within the access funds of helping people understand access to medication abortion. The benefit of where we are now compared to before Roe is that we do have more ways to administer abortion care, including medication abortions, which can help people who are particularly isolated. Although there are state laws regulating the administration of medical abortion as well. But there are a lot of people who are questioning those laws and willfully violating them to ensure people get access. So there's a lot of activism happening on the ground, ensuring that no matter what happens, individuals who need abortion care will receive that care. So here in New York, we are very well insulated from restrictions, and Governor Hochul has actually just a few weeks ago reaffirmed New York State's commitment to abortion access for New Yorkers as well as for anybody else who needs access to care. And that includes addressing misinformation on social media and issuing a patient's bill of rights so that every person knows, what their right is when it comes to reproductive health care. And thank you so much. Thank you, Shannon, and to Sherry for, I think, suggesting I come and talk.
Well, I think it would actually also be kind of important to maybe continue to have you on the show, as Dr. Proctor was saying, because I forgot where we stand with because I'm working. There are about 10 cases that are represented in the section of May It Please the Court that focuses on reproductive rights. I think we were somewhere in the middle, and if schedule's allowing, I'd like to return and possibly before the end of this semester, at least have one more show where we tackle another one of the cases, and to have a historian on board as well as somebody who's a philosopher on law. That might be an interesting combination. So it's all coming together that way. So we're almost out of time. I want to just thank both our guests today, Dr. Chelsea Del Rio from the Division of Academic Affairs, Department of Social Science, historian in that department, and Dr. Shannon Proctor from the Humanities Department's philosophy area. I also want to thank Dr. Carr, who has been kind of like a shadow guest, a shadow authority and guest on the show, and particularly for her suggestion that we focus on this, bringing it into now. I mean, my notion was always that we'd go through the history of cases, but we did know that coming to this fall, and I think Dr. Albrecht had mentioned this, that we were walking into the Roe situation coming finally to a head. I just want to thank you both for being on the show today. The show is What's Going On. I'm your host, Hugo Fernandez. And tune in. We're going to have a special show on Friday with the president and Dr. Anna Maria Hernandez and Dr. Joy Sanchez Taylor to talk about the new Hispanic Heritage Center. And I would like to take out the show as we began with a little more Fleetwood Mac and Stevie Nicks. And Mr. Pope, our engineer, had to deal with some technical issues today, but handled them. Please take us out. Thanks for watching. Thanks for listening.